In Camillus, New York, just west of Syracuse, an Occupational Safety and Health Administration compliance officer, Ashley Irwin, was driving by an excavation site. Applying OSHA's plain view doctrine, Officer Irwin pulled over and commenced an investigation. She recorded much of it on video footage. There at the site, she noticed at least one worker inside an excavation that was apparently deeper than the worker was tall. Laying at the immediate edge of the excavation, a spoil pile comprised of loose soil and aggregate. Also at the very edge of the excavation, and slightly hanging over the edge, a 25-ton excavator, the Caterpillar 320. Officer Irwin took measurements. She interviewed workers, and she interviewed the owner of Montroy Development LLC, the excavation operator, David Montroy. The Occupational Safety and Health Administration compliance officer issued citations which Montroy contested. Today, we'll discuss the type of evidence that OSHA presented to the administrative law judge, the type of rebuttal evidence submitted by Montroy, and why that matters to you in the OSHA 3030 community. I'm Manesh Rath, and this is the July 2025 edition of the OSHA 3030. Well, hello, everyone. As I said, I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman in Washington, D.C. For the past 30 years, I've been engaged in representing management in the field of workplace law, particularly occupational safety and health law. And I'm really grateful for being joined today by my friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you, Manesh. It's great to be here.
Well, as you know, we've got a great topic here on the OSHA 3030 today. The case is Secretary of Labor versus Montroy Development.
Yeah, and as always, we'll begin with a little more detailed recitation of the facts of the case. We'll review, as we often do, how OSHA is to establish a violation. Then we'll get into, as you said, the arguments made by Montroy, the arguments made by OSHA, and finish it up with the ALJ decision and the practical points that folks in the OSHA 30 community should take away from this case.
Yeah, I think the most important part of every one of our OSHA 3030 editions is the practical takeaway items and what employers should do. So let's start with the facts.
Yeah, so Montroy, like you mentioned, is a contractor based out of Syracuse, New York. They specialize in many aspects of project construction, but particularly in the pre-construction stage of the project, which includes excavation, like we see in this case. And they also work on utilities development, developing things like water access, electricity, storm drainage. And in a broader context, they're part of a family of companies that includes other companies that also provide construction services and actually provide snowplowing services. So they're well versed in the field of using heavy equipment and machinery.
That's right. So this all occurs on May 8th, 2023. Compliance officer driving by sees that Montroy was performing excavation work as part of its general site preparation business model. And this was for what was going to be a residential building project in Camillus, New York. And the compliance officer, Officer Irwin, what she saw while driving by and getting out of her vehicle was the excavation, and an individual appeared to be standing at the edge of the pit, speaking to someone in the pit. And she said that at some points she could see the top of the head of the person in the pit, and at other times the person was completely below the ground level inside the pit, thus concluding that the depth of the pit exceeded the height of the worker in the pit. This was important because this was one of her sort of corroborating pieces of evidence for whether or not the pit was of the requisite depth, 5 feet.
Exactly. So when the officer entered the work site, like you said, the first item that she went to investigate was the person standing over the pit and speaking to someone on the inside. And she did confirm that there was indeed someone on the inside of the pit. And at that point, she asked all the folks to clear the work site for an inspection.
Works, I mean, to get out of the pit and to step further away from the pit
Right.
than its edge. Uh, she took a look around the pit and observed that there were spoil piles going right up to the edge, and there was also that Caterpillar excavator that we talked about right at the edge of the excavation pit. And at least one point in the administrative law judge's opinion seemed to imply that it was actually hanging over by a little bit
Mm.
over the edge. So the compliance officer took measurements the best she could. She didn't want to go to the edge of the pit because it was unshored.
Right. There was concerns about the safety of her going into the pit, as it didn't have, as we'll see later with the citations turn out, it didn't have cave-in protections in place.
So she takes measurements the best she can. And all of this, she's also taking photographs and videography. And the measurements that she uses, she also has Mr. Montroy, the owner of Montroy Development, there at the time. She even has at one point him holding the other edge of the measuring tape.
Mm.
I think these are important details that she recites in the hearing before the administrative law judge.
Right. And so at the conclusion of the inspection, the officer issues to Montroy two citations, both under the excavator standard. The first citation relates to the location of one of the spoil piles, which she found was less than 2 feet from the actual pit. And under section J2 of the standard, employers are required to prevent objects from falling or rolling into open excavations. And as part of that, they have to ensure that objects are at least 2 feet away from the edge of the excavation pit.
Yeah, Ben, you mentioned the standard, and it's important to point out that this is under Section 1926. This is a construction standard. However, this is an important case, even in general industry, because what we really want to talk about today is the kind of evidence that OSHA has brought in this case, and the kind of evidence that we think an employer needs to have
Mhm.
before considering whether contesting a citation is worthwhile. So this was a construction standard, the excavation standard under Section 1926. And as you say, there's a few requirements. One of them is shoring if the excavation pit is more than 5 feet deep, and removing spoil piles to at least 2 feet away from the edge of the pit, and also equipment.
Mhm.
And the compliance officer alleged a violation of all three of those elements,
Mhm.
which I think is interesting because each one of them Montroy contested.
Right.
So, so Ben, why don't I really quickly talk about what compliance officer or what the agency has to establish in order to allege a violation of a specific standard. We've done this a number of times here at the OSHA 3030. For those of you who are attending for the first time, this is an update on OSHA law that we do every 30 days in about 30 minutes. And frequently we have cases that involve alleged violations of cited standards. Other times, allegations of violations of the general duty clause, and that has a different four elements. But here, OSHA, under a cited standard, has to allege that the standard even applies to the situation, and that indeed the requirements of the standard were violated, and that there was exposure by an employee or a worker to the cited condition or to a hazard, and that the employer either knew or should have known about the alleged violative condition. So OSHA presents evidence in support of each of these four, and Montroy contests each of these four elements and the evidence presented by OSHA.
Right. So, and one of the key aspects of how Montroy countered specifically the citation relating to the location of the pile and the excavator is that the OSHA inspector admitted in the hearing that she did not take actual measurements of the distance between the beginning of the excavation pit and the exit and the excavator and the spoil pile.
And she said she didn't take actual measurements because since the excavation wasn't shored, she didn't feel it was safe to get straight to the edge and drop a measuring tape down.
Right, exactly. And sort of dovetailing off of that, Montroy, through Mr. Montroy, who, like we mentioned, was present at the work site during the inspection, and the employee who was present during the inspection, the employee who was inside the pit, they both testified that the excavator was located more than 2 feet from the pit, and same with the spoil pile. So that was their rebuttal to OSHA's assertions in the violation.
Right. And there's some conflicting testimony on their part, but at one point, the worker testified that he thought the spoil pile was 28 inches away. Uh, what what the compliance officer had was she did take some measurements, but she took them at a distance, and uh, and she took videographic images and photographic images, and she was able to present those to the judge, along with her testimony that she believed her measurements indicated 5 feet in depth or greater, sometimes 5'8", and deeper. But at no point did she find a depth that was less than either 5 feet and a half inch, or in other testimony, more than that, 5 feet and 1 inch, and at other times greater depths of 5'8" at least.
Mm.
So so the judge found that her testimony itself was credible because the way she explained it was clear and forthright, but he also credited her testimony because it was corroborated by his own observation of the photographs and the videographic images.
Mm.
And I think that that was a critical element in the judge's ultimate decision. So Montroy comes up with its counter arguments.
Right. One of the things that Montroy pushes back on was that the excavator, the cat machine, was not within the definition of equipment of the standard. And the reasoning that they had behind this is they said, well, the excavator is a piece of mobile equipment. It's not a stationary object like the standard is designed to protect against something rolling into an excavation pit or falling into it.
Yeah, when you look at the standard, I saw no evidence that would lead me to believe that the term equipment meant fixed equipment or stationary equipment. At a construction site, indeed, I would say all or almost all equipment is mobile. And so I think that it's clear to me that the ambit, that the original intent of the drafters at the agency when using the word equipment was to include equipment, whether it be fixed or stationary or mobile.
Mm. And then relating to the citations on the depth of the excavation pit, Montroy said that the employee who was inside the pit when the inspector arrived was the operator of the excavator, and the operator testified that he went inside the pit to determine its depth because a tool that's normally located on the excavator's arm that tells distance was broken. So he just briefly went inside to determine its depth and then would leave. And the argument that they made based on this fact was that the standard applies to folks who are working inside the pit, not just someone who comes in briefly.
It's not a bad argument if so this by the way goes to the element of employee exposure. Was there any employee exposure? And I think that they're arguing that the standard prohibits working in the excavation when it's greater than 5 feet and not shored properly. But I think that it really, on the fundamental question of whether there was employee exposure to a hazardous condition, he's trying to attack that by saying the employee only entered briefly and to in order to determine the depth. And I don't know that that actually attacks the question of employee exposure at that moment. He's merely arguing that the employee wasn't performing other work other than the work he was performing, which was assessing the depth,
Right.
as if that wasn't itself also work. And that is a problem for his argument.
Right. The other aspect of the depth citation was that Montroy said that it was exempt from the standard because it was not 5 feet. It was not more than 5 feet, and the standard provides an exception to excavation pits that are under 5 feet. And again, I think the problem with Montroy's, as the ALJ will point out, is that they relied heavily, almost exclusively on this point, on just testimonial evidence.
There was two types of testimony. One was that they said it's my testimony that it wasn't 5 feet, and the other was when you look at the photographs, it's not clear, taken by the compliance officer, it's not clear, and the evidence that she gathered was so poor because of her own incompetence that she's failed to produce her sufficiency of evidence or the sufficiency of making her case as to the depth of the excavation. But what they didn't do was present their own corroborating evidence. For example, a photograph of a measuring tape showing, or videographic evidence showing what their measurements were. And that would have been maybe the missing piece to countervail the compliance officer's evidence.
I think that's exactly right. And I think they run into the same issue on both the depth issue and on the location of the spoil pile.
Right. And one other argument they made was that the standard doesn't apply because this was firm soil and that there was rock in the soil. But the exemption for the excavation standard only applies to solid rock. The evidence was pretty clear, as presented by the compliance officer, anyways, that the soil itself was loose. That Montroy testified he hadn't tested the soil, and that it was loose, disturbed soil that had maybe been disturbed by a telecom or other utility operation prior to this operation, and that at any rate the spoil pile itself, which Montroy himself picked up by hand, a handful of, was evidence that it was loose soil and it was filled with aggregate. Aggregate only makes it looser. The fact that there's rocks in the soil isn't better than loose soil. It's about the same or worse when comparing to the exemption, which is for solid rock, excavation in solid rock. And so the judge, looking at all of that countervailing evidence, disregarded or dispensed with the argument that the standard doesn't apply when dealing with solid rock. So that's Montroy's arguments. I think that the compliance officer had presented evidence on each one of these points, and Montroy had presented its own testimony to each one of these issues. And I think the administrative law judge did a fair job of addressing them one by one.
Yeah.
The compliance officer's arguments.
Yeah, so the compliance officer, like we discussed at the beginning, I think the reason there's a lot of pushback from Montroy as to the sufficiency of the measurements and other evidence that the OSHA was able to proffer, but I think all of it is undergirded in a very practical concern that the officer had when she was on site, that she believed that taking more precise measurements relating to the location of the spoil pile and the excavator was unsafe because of the lack of protections in the excavation pit. So that's something that OSHA stressed in their side of explaining why they did not have more precise measurements in some respects.
Right. The recordings were also helpful to the agency in this case. Well, for one thing, when it comes to exposure, Mr. Montroy argued that this was a very brief exposure. The employee only went down there to determine whether indeed it was 5 feet. I think dropping a measuring tape down would have been a safer approach. But in addition to having safer alternative methods than actual exposure, the duration of the exposure isn't really to the point. Nevertheless, the compliance officer's countervailing evidence was a videographic image of Mr. Montroy speaking to the worker who was in the trench or in the excavation for at least 30 seconds of video footage.
Right. Yeah.
And that was by the time she had pulled up, saw the worker in the excavation, had time to park, get out, start her phone or what other video recording device she was using. So there was lost time prior to that, which she testified the employee was in the excavation during. So that's a significant amount of time, I think, when compared to Mr. Montroy's testimony.
Yeah, exactly. And I think the on the issue of the depth of the pit, the compliance officer in this case did take measurements, and she did it in sort of a makeshift way where she dropped a stud board at the bottom of the pit and then dropped a measuring tape down and recorded the depth minus the thickness of the stud board and concluded that it was 5 feet 3 inches.
At minimum.
At minimum, exactly. And I think this was also corroborated by the video testimony that she had, and like you mentioned, where she had Mr. Montroy holding the portion of the measuring tape that measured out the depth.
Right, and he didn't object to the methodology at the time on video, which would have helped him when later he testified that her method was not an accurate means of measuring. All right, so the administrative law judge hears both sides.
Yeah, here's both sides, and like we alluded to, does fall in favor of OSHA on this one. And I think a large aspect of it just had to do with the fact that Montroy did not have anywhere near the sufficient amount of corroborating evidence to back up their testimony, and that really is the crux of the case, is that testimonial evidence is helpful, but more is needed to be able to, I think, convince folks, especially the LJs, that the citation that OSHA issued to you is not warranted.
Right. And as to the amount of time that the worker was in the excavation, the judge said, well, the amount of time isn't really specified for exposure. Exposure is exposure, and the employee shouldn't have gone down into the excavation unless it was properly shored or that it had, the right amount of sloping, such that there was alternative, equally protective means to allow for workers into the excavation for any duration of time.
Mhm.
I think that the judge also one by one handled the evidence as to the distance from the edge of the spoil pile and the excavator machinery by saying that the video or photographic evidence corroborated the compliance officer's testimony. And as you say, Ben, I think that the overarching theme here for the administrative law judge's decision to me seems to be that testimonial evidence by the employer is simply not going to be sufficient by itself to countervail evidence by the agency that is both testimonial and corroborating the testimony. There's also these other means of presenting evidence like photographs and videographic evidence. Well, I think that that's the probably the most significant feature of this case when I read it was the type of evidence that Montroy thought was sufficient and the type of evidence that the LJ found to be insufficient. In addition, I think he also just found the compliance officer's testimony to be credible all by itself, but the corroborating evidence simply made it more helpful for him to make his credibility findings. With that said, why don't we talk, Ben, about what we think employers should do in light of the Montroy case?
Yeah. So I know that the first point is to ensure that when a OSHA inspection takes place, that the supervisor or employee supervisor or a designated employee accompanies the compliance officer during the inspection.
That's right. I think it could be a supervisor, a project manager. It'd be helpful if it was a safety and health professional, and you can have all three of them accompany the compliance officer on the inspection. I think the other thing I'd say is it's imperative for the employer to be taking the same evidence for its own records as the compliance officer is taking. So if the compliance officer takes a photograph, the employer should take not only the same photograph from the same location, but should also take multiple photographs from multiple locations. If the compliance officer takes videographic evidence, the employer should have somebody taking videographic evidence as well, hopefully the same and also better videographic evidence from multiple angles at multiple zoom lengths. There should also be a narrative on the video as to what's taking place on the employer's video, measurements being taken, where it's being taken from, etc. This applies beyond the excavation standard. As you know, Ben, there's similar problems with inspections that take place under health standards. If there's sampling, air sampling, for example, that has to take place, or employee monitoring that has to take place, employers should conduct their own sampling and monitoring as well. And they should ask the compliance officer what equipment they're using and what settings they're using for that equipment and when it was calibrated, if it was calibrated, if the compliance officer knows when it was calibrated or whether it was calibrated or has records of calibration, right then and there. If there's photographs being taken, the employer should ask, what are the settings you're using for your camera? What is the aperture? What is the zoom length? What is the f-stop? Same with videographic evidence. All of this, that's really two components that we're emphasizing here, Ben. Not only what is the opportunity for the employer to take their own equivalent record, but also what were the settings, what was the calibration of the compliance officer's record, whether it was air sampling or videographic or photographic evidence. I think that's maybe one of the most important things an employer can do during the inspection. Now, let me just expand a little further. Often, if not always, the compliance officer will ask for certain records. And I think it's important for the employer to keep a list of what records were provided to the compliance officer and a separate copy of documents provided to the compliance officer.
Yeah, and I think related to that process that you described, Manish, it's important before at the initial stage, right after a citation is issued, is to conduct your own internal investigation to assess what kind of evidence you possess, what kind of defenses may be available to you, and to do this with OSHA counsel if possible.
Yeah, I think that's helpful. Well, you mentioned OSHA counsel. I think that's an interesting point. I'm not sure. It's not clear to me that Montroy had an attorney. There was somebody identified as a representative for Montroy, and I don't see any indicator that that representative was an attorney. Maybe a safety consultant, maybe an attorney, but I don't see the evidence of that. The administrative law judge referred to the person as Montroy's representative.
Mhm.
But of course, we would feel better if employers worked with an attorney to evaluate what their defenses are and what evidence they have to support those defenses before even bothering with a notice of contest,
Mhm.
and preferably an attorney who's immersed in OSHA law because it's a unique area of law. And as you know, it's many volumes thick, just the standards alone. And the procedures are unique to OSHA law. It exists within its own ecosystem of administrative law judges and a review commission, not in Article 3 courts until the final appellate stage. And so an OSHA lawyer representing employers is probably the best person to consult. I don't see the evidence that Montroy did that. They may have. And I think that that was a critical opportunity for Montroy
Mhm.
to maybe have had a better outcome than this. As you noted, the administrative law judge ruled flatly against Montroy and soundly in favor of the compliance officer.
Mhm.
And in this case, given the defenses I saw by Montroy and the evidence that they presented, I think that that was the right decision.
Mhm.
I don't see any question of that. There may be facts that we, reading the opinion, are unaware of that would certainly change my mind possibly, but just based on the face of the decision, I see missed opportunities on the part of Montroy had they worked with an OSHA counsel to evaluate their evidence and their defenses maybe a little differently.
Sure.
And your point is well taken, if, especially if there was an injury or a fatality, to conduct an investigation and to conduct a thorough investigation. But to assess the defenses and the evidence prior to issuing a note of contest and reassessing it constantly as more evidence emerges through that internal investigation to find out what caused any accident, injury, or fatality, and to evaluate on an ongoing, evolving basis whether or not your defenses have changed.
Right.
I think that that's a really critical opportunity for employers. I also think it's their responsibility to be a little bit thoughtful and a little bit maybe strategic and deliberate about the defenses that they raise
Mhm.
to make sure that they are bona fide defenses and not just contesting everything
Mhm.
when it doesn't maybe make sense. Uh, that's, I think, the upshot of what we thought the case was important for and what employers should do in light of the decision. Uh, that's today's OSHA 3030. We'll be back again on August 20th at 1 p.m. Eastern. We have participants from all over the world registering for the program. So I should point out this is 1 p.m. United States Eastern Time, August 20, 2025. That's the next OSHA 3030. We have sister programs. Many of you know if your company is responsible for compliance with REACH or TSCA, you should know that our next programs, TSCA 3030, August 13th at 1 p.m. Eastern US, the REACH 3030 on August 27th, 10 a.m. Eastern US. Please forward the good word about those programs to those colleagues within your company responsible for compliance with REACH and TSCA. And as we've always asked, and thank you for those of you who keep doing it, every time you get an invitation, find 3 new people within your organization and at other organizations that you can forward the invitation to spread the good word about the OSHA 3030. I want to thank all of you for participating for 12, 13 years now. Every single month, we've had people who have consistently attended on a monthly basis for since the beginning, and we've had new participants coming in thanks to your efforts to spread the good word. It just takes a few seconds to send out an email. So thank you all. Thank you all for participating in this OSHA 3030. I want to thank my staff here at Keller and Heckman who do a wonderful job of producing and editing the program. My colleague Ben Idzik, who I enjoy working with on behalf of employers in the field of OSHA law in federal states and state plan states in virtually every jurisdiction in the country. It's always a pleasure to work with you on a daily basis and to put these programs on as well. So thank you as well. And thank you all. We look forward to seeing you again next month. And until then, stay safe.